A Supreme Court decision just dropped that most people are misunderstanding, and if you repeat the wrong take online, it could hurt your rights instead of helping them. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could save you from a decade in prison. Hit that button now. All right, let's talk about the headline you've probably seen everywhere. Breaking Supreme Court 8-1, decision just changed both First and Second Amendment rights. Here's the truth. There's a real 8-1 Supreme Court decision tied to the Second Amendment. And there's also a huge Supreme Court moment tied to the First Amendment that affects gun groups and gun speech. But they are not the same case, and mixing them up is how people get confused fast. So in this video, I'm going to do three things for you. First, I'll explain the real 8-1 decision, what it held and what it did not hold. Second, I'll explain the First Amendment side and why it matters to gun owners, even if you hate politics. Third, I'll give you real-life examples so you know what to do and what not to do, especially if you ever deal with restraining orders, social media posts, or pressure from government officials. Because if you don't understand this, you could believe a myth, and the myth could cost you your freedom. Segment 1. What actually happened in the 8-1 Second Amendment case? The case is called United States versus Rahimi. Here's the simple question the Supreme Court answered. Can the federal government temporarily ban someone from having guns if that person is under a domestic violence restraining order, and a court has found that person is a credible threat to someone's physical safety? The Supreme Court said yes. That's the headline in plain English. If a judge has found you are a real threat to someone's safety, the government can disarm you while that order is active, and it does not violate the Second Amendment. Now, I want you to notice what the court did not say. They did not say the Second Amendment is gone. They did not say anyone accused of something loses gun rights. They did not say states can disarm people just because they feel like it. This decision is about a specific type of court order with specific legal requirements and a specific kind of finding, a credible threat. That detail is everything, because a lot of people online are treating this like the court just approved broad gun bans. And that's not what this case was. Now, here's where it gets interesting. This case also matters because of Bruen. If you follow gun law even a little, you've heard of Bruen. That's the Supreme Court case that told courts to judge gun laws by looking at history and tradition, not by doing a modern balancing test where they weigh rights against public safety like a scale. After Bruen, lower courts started fighting about what history and tradition means. Some judges started acting like the government has to find a perfect copy of a law from the 1700s to justify any modern gun rule, like a historical twin. And the Supreme Court in Rahimi basically said, stop doing that. They said the Second Amendment is not a law trapped in amber. In normal words, that means the Constitution is not frozen like a bug in a block of ice. You don't need a perfect historical twin. You need a historical analog. Analog just means close enough in the important ways. The court explained that the key is the why and the how. Why does the law exist? What problem is it trying to stop? And how does it burden the right? How far does it go? How broad is it? How long does it last? That's the new battleground. So even though Rahimi is about restraining orders, it also sends a message to every lower court in America. You're not allowed to demand an exact match from 1791. You must look for a comparable principle. That is huge. Now let's make this real with a story, because stories are how you remember this. Imagine a guy named Mike. Mike is not a felon. He's not a gang member. He owns guns legally. He carries legally. He's just going through a nasty breakup. His ex files for a protective order. Mike thinks, this is family court stuff. It's not criminal. It's just paperwork. It'll blow over. That is the mistake. Because if the order checks the right boxes, and especially if the order includes the wrong kind of finding, Mike can suddenly be in federal felony territory just for possessing a firearm while the order is active. And that's why you can't treat restraining orders like a joke, like drama, or like a temporary inconvenience. Temporary can still mean handcuffs. Temporary can still mean thousands of dollars. Temporary can still mean you lose your rights long term. Now, the next question is the one everyone asks. Okay, but how can the court do that and still say we have a right to keep and bear arms? Here's the simple answer. Even in the big pro-gun cases, the court has said the right is not unlimited. Not unlimited doesn't mean weak. It means there have always been some rules. The Rahimi majority explained that, historically, American law has had ways to stop people who threaten violence from misusing weapons. They talked about older laws that tried to prevent violence and punish people who terrorized others with weapons. In plain English, the court said, if you're a real threat, society has always had tools to deal with you, and disarming you temporarily fits that tradition. Now, this is the part that shocked a lot of people. Rahimi was 8-1. That means it wasn't a close 5-4 case. It was an overwhelming majority. Only one justice dissented. So if you were expecting the court to be split straight down party lines, this case didn't do that. Now, I want you to listen closely, because here's a detail most people miss. Rahimi was what's called a facial challenge. In normal language, that means he wasn't saying, "This law is wrong in my case." He was saying, "This law is always unconstitutional, no matter what." That is the hardest kind of challenge to win. Because to win, he had to show the law could never be valid, not even once. And the court said, basically, we don't have to decide every imaginable situation. The law is clearly valid in situations like yours, where a court found you were a credible threat, so he lost. And when the court decides a case that way, it matters, because it keeps the decision narrower than people think. It's not the court saying, "We approve every possible use of this law." It's the court saying, "This law is constitutional, at least in the kind of situation we have here." And that difference matters if you care about due process. Now let's jump to segment 2, because this is where the headline tries to connect the First Amendment. How does the First Amendment get pulled into this story? It's not because Rahimi was a First Amendment case. It wasn't. The First Amendment part comes from a different Supreme Court fight that hits the gun world in a different way. Here's the First Amendment issue in simple terms. The government cannot use its power to secretly pressure private companies into punishing speech the government doesn't like. That includes gun speech. That includes gun advocacy. That includes groups the government wants to cancel without passing a law. Why does this matter? Because in real life, the fastest way to destroy a group is not always to outlaw it. Sometimes it's to cut off banking, cut off insurance, cut off payments, cut off basic services. And if government officials can suggest to regulated companies that they should stop doing business with certain speakers while waiving the threat of investigations or enforcement actions, that can become a backdoor way to silence speech. That's a First Amendment problem. And gun owners should care because the gun debate is not only about firearms. It's also about whether you can talk about firearms, organize around firearms, and advocate about firearms without being targeted. Most people think, I only care about the Second Amendment. But the First Amendment is the engine that lets you defend the Second. If you can't speak, you can't rally support. If you can't organize, you can't fund lawsuits. If you can't advocate, you can't push back. So when you hear both amendments changed, the smarter way to understand it is this. The Supreme Court clarified how courts should judge certain gun laws under the Second Amendment, and it reinforced limits on government pressure that threaten speech under the First Amendment. Two separate lanes, but they can collide in the real world. Now let's get into what everyone wants to know. What changed for you today? I'm going to give you 5 big takeaways. First takeaway, credible threat is not just a phrase, it's a trigger. In Rahimi, the court cared that a court had found he was a credible threat to physical safety. So if you ever get hit with a protective order situation, you need to understand what the order actually says. Does it say you're a credible threat? Does it contain findings about violence? Does it explicitly ban threats or force? Those details can decide whether gun possession becomes criminal under federal law. Second takeaway, notice and a chance to be heard matters. A big reason the law in Rahimi is structured the way it is because it involves court procedures. In simple terms, the system is supposed to give notice and a chance to respond before the restriction kicks in. That doesn't mean the system is perfect. It doesn't mean you're safe if you ignore it. It means you must take it seriously and show up, because ignoring it can become the very thing that makes your situation worse. Third takeaway, temporary can still destroy your life. People hear temporary disarmament and think it's no big deal, but if you get charged, you're not dealing with temporary stress. You're dealing with permanent consequences, legal fees, a record, restrictions. Even if you win later, the process can punish you. That's why you should never gamble with this stuff. Fourth takeaway, Bruen is still the test, but the court wants it used a certain way. Rahimi, it does not erase Bruen. It does not replace Bruen. It tells courts how to apply Bruen correctly, and that means something for future gun cases. Because a judge can't just say, I didn't find a perfect law from 1791, so the modern law fails. Now they must ask, does this law match a historical principle in the important ways? That can cut both directions. It can save some laws. It can sink other laws. But the key is, the court is telling lower courts to stop playing games with historical twins. Fifth takeaway. The First Amendment matters more than most gun owners realize. If you run a gun shop, teach classes, post content, or support groups, you may be affected by the speech side of this world. Because pressure can come through channels you don't expect. Banks, insurers, platforms, processors. And the legal fight over whether the government can push those channels to target certain speakers is a major part of the future. Now, right around now, if you're still with me, I want to hit you with a simple truth. A lot of gun owners lose rights without ever committing a gun crime. They lose rights because of paperwork, because they ignored a hearing, because they assumed civil means safe, because they got bad advice from the loudest guy on the internet. Don't be that person. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. Now let's get more practical. I'm going to walk you through 3 scenarios, and I want you to imagine yourself in them. Scenario 1, the traffic stop. Imagine you're driving home from the range. You have a firearm locked in your case. You're legal. An officer pulls you over for speeding. Now you're nervous. You start over-explaining. You start reaching. You start talking fast. Here's why this ties into today's topic. Because your words are your First Amendment in action. And your firearm is your Second Amendment reality. And the worst thing you can do is panic and create suspicion where none existed. I'm not telling you to argue. I'm not telling you to be rude. I'm telling you that understanding rights is not about acting tough. It's about acting smart. Scenario 2, the messy breakup. Imagine you and your partner are splitting up. Things are tense. One night, you send an angry text. Not a threat. In your mind, just anger. But the next day, you get served with a protective order request. Now, here's the mistake most people make. They think, this is emotional, this is personal, the judge will see that. But the court is not reading your mind. They're reading what's on paper. And if an order gets entered that includes findings about threats or danger, it can change your gun situation fast. So the smart move is simple. Take it seriously early, get counsel, understand the terms. Don't violate the order. Don't send just one more message. Don't show up just to talk, because the system doesn't care how you meant it. It cares what you did. Scenario 3, the quiet squeeze. Imagine you run a small gun-related business. You sell parts. You do training. You make holsters. You teach safety. You're not doing anything illegal. But one day, your payment processor drops you. No warning. Then your bank starts asking weird questions. Then your insurance broker says your policy won't renew. You ask why, and nobody gives you a straight answer. This is the part that should scare every person watching. Because even without passing a new gun law, a coordinated pressure campaign can make lawful businesses and lawful speech harder to sustain. And that's why the First Amendment side of this story matters. Now let's address the biggest myth I've seen in comments. People keep saying, so this means as if someone gets accused, they lose guns? No. Accusation is not the standard in this case. The decision talks about a court finding tied to a credible threat, and the law has procedural requirements. That doesn't mean the system can't be abused. It means the court's logic is grounded in a process and a finding, not a rumor. And here's another myth. People say, so the court just said the government can disarm anyone it calls dangerous. No. In fact, the court did something important. It did not accept a sloppy label like not responsible as the whole answer. In normal language, the court did not create a blank check where the government can just slap a label on you and take your rights. They focused on a credible threat finding and a tradition of dealing with real threats. So if you care about due process, you should understand that part too. Now, I'm going to say something that might annoy some people, but it's true. If you are a gun owner, you have to be the most boring, careful person in the room when conflict starts. Not because you're weak, because you have more to lose. The law is not forgiving when guns are involved. A mistake with a gun is treated like a bigger mistake than the same behavior without a gun. That's just reality. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. All right, segment 3. What this means for the future gun law fight. This is where the changed both amendments headline gets its power. Because Rahimi is going to be cited in almost every major Second Amendment case for one reason: the historical analog language. Courts have been all over the place after Bruen. Some struck down laws quickly, some upheld laws quickly. Some demanded extremely specific historical examples. Others allowed broader comparisons. Rahimi signals the Supreme Court is watching that chaos, and it's telling lower courts, stop demanding impossible history. Use analogy and principle. Now, that can do 2 things. It can help the government defend some gun laws, but it can also help gun rights plaintiffs because it forces courts to be honest about the history they're using. No cherry picking, no pretending a right only existed for perfect people, no making up standards out of thin air. Instead, courts have to focus on why the regulation exists and how heavy the burden is. Now, let me give you another hypothetical example to make this simple. Here's a hypothetical example to explain this. Imagine a state says, anyone who has ever been treated for depression can't own a gun. Most people would say, that's too broad. Under the kind of reasoning discussed in Rahimi, a court would ask, is this aimed at a real, proven threat, or is it a broad category rule? Is there an individual finding? Is it temporary? Is there due process? How heavy is the burden? That's where these cases are going. They're going to fight over how targeted a law is, how much process it gives, and how much it looks like historical tools aimed at preventing violence. So if you're watching future cases about bans, permits, carry zones, and more, keep your eye on one question. Is the law narrow and tied to a specific danger finding, or is it broad and based on category labels? Now let's tie this back to the viewer, to you, because I don't want this to be abstract. If you only remember one thing from this entire video, remember this. Most people don't lose rights in a dramatic shootout scene. They lose rights in boring moments: a court date they skipped, a form they didn't read, a message they shouldn't have sent, a restraining order they assumed wasn't serious, a bad decision made in anger. And the law does not care that you're normally a good person. The law cares about what's written, what's filed, what's ordered, and what you did next. Now, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. Now let's talk about what you should do right now. I'm going to keep this simple and calm. If you have no restraining order issues in your life, great. Your action is learn, stay updated, and don't spread bad headlines. If you're currently under any kind of protective order, your action is read it carefully, follow it strictly, and talk to a lawyer in your area about the firearm implications. If someone is threatening to file an order against you, your action is don't send angry texts, don't escalate, don't go explain yourself, and don't rely on internet advice. Get real legal help. If you run a gun-related business or organization, your action is understand that free speech protections matter, and watch how these cases affect pressure campaigns and deplatforming. And if you're a content creator, your action is be accurate. Because spreading the wrong legal take doesn't just make you look bad, it trains your audience to take the wrong risks. Now, before we wrap up, I want to address one more thing. Some people will use Rahimi to argue that gun rights are shrinking. Other people will use it to argue gun rights are safe and nothing changes. Both are oversimplifying. Rahimi is not the end of the Second Amendment, but it is a major signal flare about how the Supreme Court expects Bruen to be applied. And when you combine that with First Amendment rules about government pressure and suppression of speech, you see a bigger message from the court. Rights are real, but they come with rules. And government power has limits, but you need to know where those limits are. Now, here's the last warning, and I'm going to say it as plainly as I can. Do not assume you're safe because you're not a criminal. Federal law can apply to people who have never been convicted of anything if they are under a qualifying court order and they possess firearms anyway. That's why awareness matters. That's why precision matters. That's why you can't treat this like internet gossip. This information could literally expire after January 2026. Subscribe now because the next video explains exactly what you need to do before that deadline hits. All right, closing. Here's the key takeaway. The Supreme Court's 8-1 Rahimi decision says the government can temporarily disarm someone who has been found by a court to be a credible threat to another person's safety. It also clarifies that courts should use historical analogues, not demand perfect historical twins, when judging gun laws. And the First Amendment side of this broader story is just as important. The government can't use backdoor pressure to punish speech it doesn't like, including lawful gun advocacy. If you care about your rights, you need accurate information, not viral headlines. So please subscribe, because I'd rather you hear the truth here than learn it the hard way in a courtroom. Final disclaimer in simple terms: I'm not your lawyer. This is general educational information. Laws change, facts matter, and states differ. If you have a real legal problem, talk to a qualified attorney before you act.